Okay. There might be some people still hanging over with the coffee break, but I think we should be starting because then there's lunchtime. In between the coffee break and the lunchtime, there's us. So, well, my first part is to salute you, to say hello to everybody on behalf of our dean, Fulvio Cortese, who unfortunately is not here today because he's away for a conference. And the faculty is really very happy to host the Common Core after so many years. It's the 25th anniversary, a lot of memories, and just moving around the faculty, you pop up in faces and you recognize them, and it's a real pleasure. And it's a pleasure also because much has been going on meanwhile, not just from the point of view of the Common Core, but also on the subject matter that is covered by the Common Core, the development of European private law, and a number of issues. So I think that's an excellent opportunity to take stock of what has been done during the 25 years, and also to see what looks ahead in the future, because in some sense it's a story of successes, but it's also a story of crisis, and I think we don't have to underplay that. There are a number of things that are not working properly, and somehow this reflects on our working as lawyers and as comparative lawyers. So thank you for having made the journey to come to Trento, and I'm really happy to welcome you back. So thank you.
So good morning. It is a pleasure to welcome you all in Trento. My name is Elena Ioriatti. I'm professor of comparative private law at Trento University. And in the past, the project Common Core of European Private Law was part of the tradition of the Trento Faculty of Law and a component of a positive synergy. On one side, the Common Core was known as the Trento Project, and this gave great visibility to our faculty around the world. On the other side, the project was carried on in an environment in which comparative law methodology and internationalization were and still are a structural component of our studies and teaching. So it is not only a pleasure, but a real value hosting the project in Trento again, thanks to the efforts of Ugo Mattei, Mauro Bussani, our Dean Fulvio Cortese, and the comparative law colleagues, particularly Luisa Antonioli and Andrea Pradi. So I have mentioned the word tradition. I borrowed the description of this word by our former rector, now judge of the Italian Constitutional Court, Professor Daria De Pretis, who together with the vice president of the court, Marta Cartabia, recently in this faculty reflected on the meaning of the word tradition. They underline that this word has a dynamic nature. It refers to values that belong to the past, but that are still influencing the present and will contribute to build up the future. So the Common Core project is part of our tradition, part of the tradition of the faculty and of the comparative law research in Europe. Tradition is also the fil rouge of the two presentations of this panel dedicated to Professor Lando. Both presentations will start from Lando's work to underline how he has been a catalyst for a process of development of the legal studies in different fields towards the future. So I'm giving the floor to our two speakers of today, who I thank you very much. First to Professor Schaeffner-Erp, and then to Professor Luisa Antonioli, and at the end a debate will follow. So Professor Schaeffner-Erp, who doesn't really need a presentation, but still is Professor of Civil Law and European Private Law at Maastricht University, visiting Professor at Trento University and the University of Oldenburg in Germany, Secretary General of the International Association of Legal Science, Board Member of the International Institute for Justice Excellence, Deputy Justice of the Court of Appeal of Sertogenbosch in the Netherlands, immediate past Vice President of the European Law Institute, and past President and Honorary Member of the Netherlands Comparative Law Association. So thank you very much, Professor Verherp, for being here, and I give you the floor.
Thanks so much, Louisa. Thank you very much for introducing me. I'm used to, when I give presentations or talk, to stand. So the chair and my colleague allowed me basically to stand and address you. I would like to start my tribute to Lando with a quote from one of his articles. And in that article, he addressed this particular project. Now, he wrote that article at a moment that the project was very new. It had just started. And in fact, it is the Common Core project that brought me to Trento for the first time 25 years ago. What he says is that for a scholar, the truth is the ultimate goal. The scholar will not hide information, which is unpleasant. You will strive to obtain and convey all relevant information that is available. You have to be unbiased. And he then refers to Cecil and others working toward the unification of European private law. They will need all the information that is available based on unbiased research. Now, when you read the tribute written by Hugh Beale in the European Review of Private Law, the tribute to Lando, you will see where this comes from his personal life, his personal history, his upbringing. You should never, ever be afraid of things with which you do not agree. Now, what does that message mean for us today? Now, his approach is clearly functional. So we look at how do rules, how does case law, how does that work? And do not get distracted by differences that are merely technical. Look under the surface of technical rules. But then even within that approach, you have to be careful. You have to ask questions like, what is it that I want to know? Which functions am I looking for? What type of functionality am I looking for? Because you can say we start case-based, fact-based, but fact and rule can very difficult be separated completely. So you need to know, what are you looking for? You have to be aware of what Rodolfo Sacco called the formants, but we all know that. We are all comparative lawyers. We also have to be very clear about the subject we're doing research about. And this morning I attended the session on property law, and again, information and data surfaced. Now that was a topic that within this project already was discussed 25 years ago and keeps coming back. But information is broad. Shouldn't you focus? Or are we focusing too much? 25 years ago, but I will say a little bit more about that, we thought we focused too broadly. Today, perhaps we focus too narrowly. So let's see. A functional project, like any project, needs, of course, management. And there you can be fairly strict, Lando writes, or you can be fairly liberal. But if you want to have a consistent project, you need to be strict. In a comparative project, the aim of that project must not be beforehand, we need to unify, we need to harmonize, or beforehand, we need to make clear that I am different, that the common law is better than the civil law, or that the civil law is superior to common law. If we start comparative law from that perspective, we are biased from the very beginning. Now, what does this mean when we look at what we now call digital ecosystems? So, blockchain environments, and so on. And I'll tell you why I'm focusing on that. As you may know, I'm very much involved in the European Law Institute, so the European counterpart of the American Law Institute. And within the ELI, I co-chair 2 projects in the area of IT and law. One is on blockchain and smart contracts, already mentioned this morning during the property law session. And the other one is on access to digital assets. I'll come back to the two projects at the end of my talk, but given my involvement and given the importance which the ELI gives to the IT developments that we see in our society, I'll focus on that. Now, first of all, if we follow Lando's approach, we need to know what we're talking about. So we need to know what is the IT that people keep saying is so important. So everyone has an idea about Bitcoin. But a lot of people do not know that you can use Bitcoin for completely different purposes than money. That you can convey different types of information through Bitcoin software. You also have to follow developments very closely. For instance, in our blockchain and smart contract group, we have engineers, software engineers, explaining to us what is going on, what is happening. Because most of us may have an idea, but we don't really know what is happening. It goes fast, very fast. So we need to understand IT first. We need to understand our society around us. What's going on? And then, when we see what's going on, we can say, okay, what do we want to do with that knowledge? In the area of IT, the question then is, should we focus on national solutions? Because that's the only feasible approach, because countries are now defending themselves as if they were in war with one another. Or shouldn't we? Should we focus instead on regional or even global solutions? But then we face huge difficulties. Even if we decide or can decide on what we should do, the question is how? Should it be a recommendation, a model law? Within the European Union, do we need rules? What type of rules? Harmonization, unification? So, why start with comparative law in the first place? Why not say, let's have the debate on policy first? Right? That's so typical for tort law and for contract law in the area of consumer protection. So why not have that debate first? Well, first of all, and it's a little bit of a political statement, but not from a political view that I have, but what I see. What I see in Europe is growing disintegration. And countries saying we want to control the data flow in, around our countries. We want to build walls. China has a wall. Russia is working on a wall. The United Kingdom is working on a wall. When I look at legislation, the legislation that I see in Europe coming up is national. So what you see is that after a period of integration, we are entering a period of disintegration, where countries fall back to old notions of sovereignty. They want control within their borders. Will it work? That's something else. But if in that environment we start by saying, okay, we're going to propose European rules, you will meet resistance, political resistance from the very beginning. So it's far better to say, let's have a look at what's going on, and do these attempts to return to sovereignty work, and then show that perhaps they do not work, and that falling back to earlier approaches concerning integration is much better. Now, 25 years ago, when within this project the problem of data and information already came up, our society was completely different from today's society. I think that's the reason why we decided to narrow it down at the time. What we saw was just what I call a flickering of today's data-driven society. So questions concerning, can you own information? What is information? What are data? These questions were considered to be either purely related to intellectual property law or to trade secrets law, but that was it. I can tell you from experience that many of my colleagues said it's a non-issue. And even today you can find several cases, English cases, saying ownership of information is a problem that we cannot handle So there is no ownership when it comes to information. We need specific questions. So what do we have today? A world very different from that 25 years ago. We have a data-driven society where we have blocks, that is, units of information which are immutable. We have blockchains where these blocks are connected. We have distributed ledger technology, so we can store these blocks and the changes in a whole series of computers where every computer has a full overview of who has a block and what happened. We have smart contracts, self-executing computer programs, where already we know in practice that some of them simply have to be accepted as legal contracts, legally binding contracts, but some are purely of a, well, they're relevant to computer scientists. You need certain self-executing programs to have a computer running, but from us, from a legal viewpoint, they're not relevant. But how to separate the one from the other? We have the Internet of Things, the hybrid reality of physical things which only work when you have software. If you buy a modern car, which you cannot start with a key, but with a button, well, if the software in your car doesn't function really well, your car will not start, will do nothing. Basically, 25 years ago, we already saw that. Laptops, we had laptops. A laptop doesn't run without the software. Laptops, in a way, are the first, well, prototypes of the Internet of Things. Then we have artificial intelligence. I'll give you an example later on what artificial intelligence can do. So that is not just self-executing software, but software that learns and becomes close to being creative. And in that area, when you talk to data scientists, we as lawyers should become really scared. Not because of our jobs, because that is sometimes argued, that software can do away with lawyers, so-called trusted third parties. I do not believe that. But there is a lot going on that perhaps you might hold to be pure science fiction, but it is no longer the case. We have a data economy in which we deal in data. We might argue data should not be traded. It's privacy protected. But it happens. So should we say it should not happen and therefore as lawyers we refuse to study it? Or should we say it happens, let's see what's going on and let's see what we can do? Then we have the platform economy, where you bring offerors and those who need services together, like Airbnb, Uber, and so on. You know, this is a society which we did not have 5 years ago. What can AI do? Well, if you get my PowerPoint, you can click on this. And you may know that this year in the Rijksmuseum in Amsterdam, we have an exhibition commemorating Rembrandt. Now, my question to you is this a Rembrandt? Some of you might know, some of you not. The answer is no. This is a picture created, a painting created by artificial intelligence based on data analysis of all the paintings by Rembrandt. And it is such a perfect copy that if you are not well known with Rembrandt's work, you would believe it is his. And there are different examples, but just to show you. So we face a hybrid reality. We have a real economy, we have a data economy. We see differences between traditional law, and when I listen to your debates, I think the project for the time being focuses very much on traditional law. But we also have algorithmic law. That is, legal rules which deal with what is happening in that data-driven society. And there we are faced with the famous statement by Lessig that computer code is law. The programmer makes the law. I talk to these guys. Then they tell me, you lawyers, you're only troublemakers. The only thing you do is create problems that we then have to work around. That's an approach I find extremely worrying. We need to understand, nevertheless, that there are two types of legal thinking developing. We have the traditional type, with which all of us were being brought up, so reflexive, where you weigh, where you worry, where you have maybes. But there is the type of legal thinking where also lawyers say, well, it's all standard. It's a matter of yes, no. Why worry? We can do that in the form of an algorithm. You may end up with a situation like in my hometown, that when you park your car, you walk to the parking machine, come back. In the meantime, a car with a camera passed. There's just a driver doing nothing else but driving around. The camera says, no parking ticket available for this car. Click. And you're done. Well, you were a law-abiding citizen walking to the parking machine. You get your ticket. How can you prove that, in fact, there was no ticket yet in your car because you were walking to the machine? You cannot. So is algorithmic law what we want? How can you defend yourself against algorithms? Now, data law is complicated. Because data, by their nature, is fluid, it's non-rivalrous, you can copy it. Yes, but you can no longer copy it if it's in a block. And that is why blockchain should be studied so carefully. Because blockchain solves the non-rivalrous problem. And this is why private blockchains are now tested by financial institutions. I'm convinced, but this is my conviction, that national solutions to this sort of problems will not work, will not be effective. Now, what we do within the European Law Institute is do comparative analysis in these two areas. We've had computer programmers explaining to us various projects focusing on blockchain and smart contracts. In our meeting in January, we will have someone explaining to us how mediation and arbitration can be done on the basis of blockchain and smart contracts. I'm not sure whether it will work or not, but it's happening. We then want to study the legal implications. What is the legal nature of a block? What is the legal nature of a blockchain? What about evidence, counter-evidence? What's the economic value? And then blocks. Terminology is hopeless. If a block represents an asset, I'll give you an example. We suddenly call it a token, and we talk about the token economy. What we see happening in Europe is that a developer builds a block of apartments. Traditionally, then you split the building into rights of apartment and you sell each apartment separately as a separate unit in the land registry. Today, what we already see happening is that the building is not split in a legal sense. A blockchain system is set up in which each unit is represented by a block, a token, and when you buy an apartment, you get the token in the system, in the blockchain system. Now, in the system, your right is absolute, because the block is unique, the chain is clear. But if the building is sold to someone else, and that is registered in the land registry, can then the new owner say, sorry, I didn't see in the land register that there was blockchain, that you had tokens, I don't care, I evict you. What are the rights of token holders in that situation? It's that sort of problem that we're faced with. How to deal with that? Smart contracts I already talked about. How do you distinguish purely technical smart contracts from legally binding smart contracts? We studied in a project by the insurer AXA, where you could insure yourself against flight delays. By going to their website, you entered a few variables, then the program would calculate the premium, and in case your flight was 2 hours late, automatically you would get the money. How did the insurer get this information? From another outside source, a so-called Oracle, flight stats that would give information on whether a flight is delayed or not. Access to digital assets, then I'll round up. If someone passes away, a person's main assets today are sometimes not real, they're data. You inherit your father's laptop. Problem number one, how do you get into the laptop? Do you know the password? Problem number two, you get into it. You discover that there are email accounts, social media accounts, a bank account you never heard of because it was purely internet banking. How do you get access? How do you get access to digital assets? Bailiffs. Bailiffs want to seize bitcoins. How can they do that? If the system is so set up that it's meant to keep official organizations, institutions out. How do you do that? It's that sort of problem that we deal with in the other working group. By looking around, taking a functional approach, and in my case, remembering one of the most gentle persons I met in the comparative law world, Lando. Thank you.
Thank you very much, Professor Van Erp. I think that this project creates a very stimulating and intellectual environment, and this is really innovation and will probably allow the new generation to put forward a new vision. So thank you very much. And question will take place during the debate, so please keep your question in mind. And now I give the floor to Professor Luis Antonioli, who is Professor of Comparative Private Law at the Faculty of Law of Trento University and at the School of International Studies of Trento University. She is Vice Dean of the Faculty of Law, former Director of the School of International Studies, member of the American Association of Comparative Law, and member of the Association of Comparative Law, CIRD. So thank you very much, Professor Luis Antonioli, and give you the floor.
Thank you to Elena, and thank you to Chef. I think it's a good combination. In fact, the origin of this panel was that when we decided that we would be hosting the Common Core meeting, the 25th Common Core meeting here, I talked to Ugo and Mauro and said, well, it's a special date not only for us, but it's also a special date because of the passing away of Lando. And I met Lando a couple of times. I was not very familiar with him, but I have a good memory of his gentleness and his capacity to speak to everybody. And looking back and trying to get some synthesis of what has been going on in these 25 years, I really feel that Lando has been some kind of starter of a debate that has been going on for until now, and it's probably going to continue in the future. And I think what the chef has just told us is the path of how do we devise rules? We need to do things, we need to find rules, and we have to do it in the proper way. So that's the very much normative side of Lando. The Common Core is traditionally on the other side of the barricade. That is purely analytical. At least this is the stance that we've been taken. But at the end of the day, and everybody's aware of that, but I think what has happened with the PECL, I think, shows very well the fact that you cannot keep the two aspects distinct, that the analytical, scientific side of it is deeply interwoven with what is going on from the normative point of view. So what I would like to do with you today briefly is to go through some of the development and try to assess what has been the process that has led to today's situation and what we can learn from that story if something is to be learned. Now, this is the picture that was sent to the people announcing the death, and I find I'm sorry, I'm very bad at technology, on the contrary to Chef, But I think it's a good picture of him. It gives the sense of a gentle person. And a person that has been having a very long career. He died at 96, so he's been working with law and comparative law for a very long time. I put some data that's on his personal career. He's been receiving honoris causa doctorates somewhere in a number of places in Europe. He's been working almost all of his life in Copenhagen, but he built up an enormous network of persons with whom he has worked. And he was also participating to the Common Core. Chef mentioned that there was also an article published, and I'll come back to that, when he was comparing his own work at the Commission on European Contract Law, and on the other side, Ugo and Mauro's article on comparing the Common Core project with other projects dealing with European law. So we're going to see a little bit how much they compare one to the other. So, as I said, the main difference between the project is the focus, because clearly the Common Core from the very start has said we are not trying to force the law in any direction, we simply want to map the law as it is. Whereas if you look at the very numerous articles and also the presentation of the PECL, they make it clear that it's about changing the law in Europe, to produce a common contract law for Europe. And I'll come back to that because there comes a link which has been, to me, negative in the long term, that is the link between contract rules formation in Europe and the internal market. So the metaphors that were used was that Ugo and Mauro spoke about the map and said we are making a reliable map of private law, or at least this is what we are trying to do. We are something different from the people who are making city planning. That is, they are looking at how the law is, but because they want to change the law and produce something new. I find the metaphor that was used by Lando also very interesting. He said the Common Core is made up of zoologists. They are looking at the strange animals that are out there and try to describe them. So in some sense, that would mean that the group working for the PECL was a kind of breeder. You want to get out of all these animals that are out there one specific animal with certain characteristics. From the point of view of the similarities, well, that's easy to see, of course. They start from a functional approach. Chef has already talked about that. A factual approach. And Lando said they are both using an unorthodox approach to legal concepts, which I think, in his mind, meant that you are not constrained by the fact that terminology and concepts are different. And that, of course, means essentially using the comparative method. Now, I want to underline also the fact that although the Lando group started working earlier because it was formed in 1980 and the Common Core started actually 15 years later, the first meeting was in 94, preliminary meeting, and then 95, the first official meeting, there was a context, a wider context in which a lot was going on during these decades. So I might just mention a few of them. The UNIDRA principle in international commercial contract, of course, a lot of people that were working for the Lando Group were working also there. And this is about rule making. It's a normative enterprise. Then you have the groups that were involved in the drafting of the DCFR, and we'll come back to that in a moment. There was the Gandolfi project, again a normative project using the Italian Civil Code as a model for producing European law of obligation. Then you have other enterprises that were more cultural in nature, like, for example, the Jus Commune casebook series, which has been very successful in producing textbooks that are truly European in their focus. The Secular Society of European Contract Law. So a number of enterprises, which meant that there was a very significant interaction and also overlap of all these groups. So the focus was different, sometimes the methodologies, but by and large they were working in an environment where there was mutual interference between all of these aspects. Thinking back to the PECL, I think what was very relevant, first of all, was the methodologies. I mean, the idea of Lando of trying to look at the American restatement experience as something that could work in a very different environment like Europe, I think, was a path-breaking idea. And it required a lot of courage and also finding the right people, which I think he managed to do, essentially because he was a person that was able to have people working together. But the other side of the coin, I think, is that the scholarly enterprise, which started as a purely scholarly enterprise, and essentially probably would think also, if not a waste of time, something that scholars who are living in another planet may spend their time working on. But at the same time, for some reason, this was the right moment, meaning that by the time that the Lando Commission started to produce some results, the European institutions started to show some interest in the enterprise. And that completely changed the nature of the enterprise, because it is one thing to simply work on your rules, see whether you can find something common, and it's another thing to consider that maybe what you're doing quite soon might end up changing the law. So I think that's where you see that this distinction, watertight distinction between scientific, analytical project and a normative project becomes slightly blurred. Although from the very beginning, the Lando Group said, we want to change the law. We need to have a contract law. So I think this link between the political side, let's say, and the legal one, I think is very important. And of course, I mentioned the fact that also from the institutional point of view, the fact that between the second half of the 1980s, the beginning of the 1990s, the institutional and legal framework completely changed in Europe because of the Single European Act and the Treaty of Maastricht is also a very important element. Now, I would like to read you this quotation of Lando because I think it shows the link that was crucial in this development. And he wrote in 2001, so it was already fairly far away, but still in that time frame, the European Union of today is an economic community. Its purpose is the free flow of goods, persons, services, and capital. The Union is based on these four flows. They go by way of contract. The contract laws of the Union differ considerably, and the unknown law of foreign countries is therefore one risk. Thus, the existing variety of contract law in Europe is a non-tariff barrier to trade. It is the aim of the Union to do away with the restriction to trade within the communities, and therefore the differences of law which restrict this trade should be abolished. So this is a kind of syllogism. We've got the internal market. The internal market is about the free flow of goods, services, goods, and capital. What do we need for that? We need a level playing field. Are the national contract rules which are different an obstacle? Yes. Then there are non-tariff barrier to trade. We need to get rid of that. So it's absolutely clear where the aim is. And that has been something that has, again, completely changed the discourse that was going on. Because while the work was moving towards a comparative analysis of the differences of the member states, and it was not about saying whether one was better than the other, when you get into that kind of track, the aim is let's get rid of variety. So that's a very strong statement, and it's something that has been always lurking in the background, because while in the scholarly field, there's always been a very strong tension between the ones that said we should harmonize the rules and those who said you cannot. There are a number of distinctions. Variety or pluralism in itself is something that needs to be protected, and this tension about the internal market. And this has come back in the subsequent moment when the Lando Commission published its work between 1995 and 2003, the three parts, and then a new enterprise started, the enterprise for the production of a European civil code. Actually, this was a work of two groups, the FOMBAR group on the study group on the European Civil Code, and the Acquis group, which had a very different characteristics, because the Acquis group was merely working on synthesizing what had been created in terms of European private law by the European Union institution, whereas the study group on the European Civil Code was continuing the work of Lando with the same kind of methodology, but stretching the scope not just to contract law, but I would say essentially to the whole of private patrimonial law. So a major step forward in terms of scope. Was it okay? Well, from the point of view of legal doctrine, the idea was you cannot isolate contract law from other partition of private law, and therefore you have to take into account property, at least part of property law, the law of obligations, and so on. If you look at from the point of view of the legal basis, that is, why do you harmonize? Well, things become more tricky, because you could probably claim that contract law is directly linked to the internal market, and therefore you have a strong legal basis to take action at the European Union level. But when you talk about the whole of of private patrimonial law, it's much more difficult to prove that there's a point, that there's a basis for the European Union to take action. And there, somehow, the process gets linked, but also, I think, gets in a position of stalemate, because there's no easy way out. So, all of you, I think, are familiar with the story. First of all, you have the resolution of the European Parliament that said we need to have a code. A resolution are a political document, not binding, but it sets the idea that out there in the European institution, someone is listening to scholars. Then you have the Commission that from the start has a very ambiguous kind of position. First, trying to map the field with the 2001 communication, and then starting to work on that, particularly by establishing the network of scholars working on a common frame of reference, which had a very ambiguous nature from the very beginning. Common frame of reference is by per se a very vague and fuzzy term. Then it said it's a toolbox. So what do you do with a toolbox? Well, you pick up something that is useful, and then you take the box and put it somewhere else. But the scholars that were in charge of doing that meant their task in a completely different way. What they did was to take it seriously, what Lando had done before, and produce something that cannot be called but a codification. If you look at the structure of the DCFR, it's a codification. Does it make sense? Of course, from that point of view, it does. You want to have a coherent, systematic body of rules. Does that fit into the picture that the European institutions were taking? No, because there was no consensus on that. So once the DCFR was published in 2009, discussion started, well, what do we do with that? And the Commission came back again and said, we have to scale it down. Let's look for something that is more limited. Let's go back to contract. At that point, sorry, I don't know exactly where I am. Okay. The proposal for the Common European Sales Law came out after a report was made by an expert group that was much smaller than the original two groups, which was an opt-in system. 29th new contract law that could be selected by the parties for their transnational, transborder sales. Did it work? No. Again, no. A number of resistances for a variety of reasons, both political and technical. At the end of the day, it was discarded. So at the end of 2014, the Commission said, we leave it there. We stop it and we move on with something else. What else? You isolate some aspects that are considered to be crucial for the digital single market. And so two proposals for directive were issued, quite long discussion, but finally in 2019 they were adopted. So it's sorry, no, I'm sorry because I should do like a, so we come back to two directives that are selectively harmonizing some aspect of law. So we come essentially full circle. We started from the fact that there was something wrong, that European Union private law was so fragmented and non-systematic. We had the convergence of the scholarly enterprises with a debate that was taking place at the European Union level, grand project, and then it faded away, and we're back to the usual technique. Now, something that I found very interesting was a discussion that was made by Miklitz about the failure of what he termed two grand projects, the European Constitution and the Draft Common Frame of Reference as a civil code. They're more or less at the same time. It's the same time span. The Constitution was failed in 2005 because of the two referenda. And the position of Miklitz, which I think I share, is that the desire to have something like a constitution and a code was highly symbolic. Those are very symbolic instruments. They signal the unity of a nation. So it was like trying to figure out that the European Union was something more than purely an international organization. But simply, those were the wrong symbols. The European Union is not a nation under any disguise. So the two enterprises failed because of the fact that they were pulling themselves from their bootstraps. They were trying to argue the existence of something that was not there. Now, of course, there are a number of differences. Of course, the DCFR was something far more technical and far more specific. But I think that what is important to see that is parallel in these two experiences was the lack of awareness of the political dimension that was lurking in the background. So I think that is something that should be kept in mind for the future. Okay, so here we are, no European constitution, no European civil code. Does that mean that European private law has failed? Well, if you stick to the idea that our final aim was having a European civil code, yes, it's a failure. Does that mean that it's total failure for European private law? No. No, and not just because we're here and we try to convince ourselves that we are of any use, but because a lot of is going on in these 2 decades. It's not just about the DCFR and the PECL, but it's about building up the context where also civil codes work. So by looking, I had a look at all the volumes that were produced over the 25 years with the discussion of the Common Core. And I found a nice quote of Hartkamp, who said, "There's more about European private law than just the question of a civil code. The development of a European law, fortunately, is not contingent upon the preparation of a civil code." And also in Ugo and Mauro's article, it was stressed that building up a shared common legal culture is an essential component of the identity of European private law. And I think in that sense, things have been going on. The Common Core is one example, but there has been much going on in that sense. There are far more lawyers, not just scholars, that move around Europe, that are able to work together, that share terminology. So this is something, research projects are developing on a European scale. Legal education is changing very rapidly. We see it constantly every day working here in Trento, that the capacity of students to be able, and the desire to move across the borders has increased a lot. We're now having, just to tell you a small example, we started a program, 3 years program, Bachelor in English. 15 years ago, it would have been, first of all, impossible to convince all the colleagues that it was worth doing such a thing. And then it would have been very difficult to recruit students that were up to the task. Apparently, now it's working. And I'm sure we are no exception. This is something that is widespread. So I think the environment, the legal, cultural environment in which we are working today is definitely very different than 25 years ago. And then another matter that I found very interesting in the looking at the development of these 25 years is also the development of private law in new forms. Probably one scholar, again, that has worked a lot on that is Miklitz, with a huge project at the European University Institute about what he terms European private regulatory law, which is typical of what is going on today in the European Union, and it's blending features of private law and public law together. Now, this is not something that is, thank you, that fits very much in our categories, but still this is something that is developing very quickly and is linking the European development to development that are taking place on a global scale. where different actors are involved, different lawmaking procedures, different kind of remedies, different kind of interests that are taken into account. So I will skip. I wrote a few things. It's not so relevant about the content. But what is interesting there, and I think this is something that is helpful for thinking about the future of the Common Core, is that our barriers or our boundaries probably need to be reshaped, meaning that it's not just about private law. I think that in many areas, private law is increasingly interconnected to other fields of law, public, administrative, constitutional, labor, and probably this should somehow be reflected in the way in which we think about our future work. And also I think there's something related to the fact that these new developments in law, not just at European level, but at the world level with the pressure of globalization, is that you need to be more open to working with other social sciences, at least, if not technology, as Chef was saying. That is, in a number of areas, if you're using, for example, benchmarks or indicators, this is an area that is expanding very quickly, is changing the feature of law, and it requires something more than merely legal expertise. So if I would say the possible future area where the Common Core research should try and focus by keeping its own identity of a comparative law enterprise, but being more open to suggestion and to cooperation with other spheres, I would say is inside law, opening from private law to other kind of boundaries, and outside law, opening the boundaries to other social sciences. So, thank you, and I'm very happy to be here after 25. I won't be there for the next 25. I'll be already retired.
Thank you very much, Luisa, for this exhaustive overview, very clear overview of the history and also of the story of European private law. And, well, I really agree with some of this very interesting consideration. For example, the fact that there was probably really a lack of awareness of the political dimension in building up the European private law, because the final product of the Common European Sale, so that was the final product of European private law, was withdrawn by the Commission for political reasons. And that was really somehow a pity, because this could be probably the real situation in which we could check how the European private law could work on the market. And thank you very much for your final remarks on interdisciplinary and open to other legal science, and for somehow even leaving away to many traditional categories and move forwards. So it is now time for the debate. We have more or less 20 minutes. So I give you the floor for questions. Yeah, Paola Iamicelli, please. This to Paola.
Many thanks for your contribution. I've liked a lot both presentation and in particular the link between those. They suggested both a methodological question to me, whether after 25 years there is also an issue about whether the same methodology that has been used so far should be somehow be under a new thought. There are many differences from about what changed in 25 years, but in particular, I think that Chef's presentation made clear one point. There are new issues that need to be tackled from the point of view of private law, raised in particular by the digital dimensions. That do not have an answer today, probably in any national private law legal system. So probably 25 years ago, 20 years ago, 15 years ago, we could address private law issue, asking, for example, each reporter to answer a question about how is your national private law about a given issue. And let us start and see together whether there is any, convergence, divergence, continuity, and rationality in rules across the European national legal systems. Now, before the issues raised by the digital dimension of the market of trade, we may need to go beyond what the national legal system offer, because probably we do not find rules within the legal system. Still, we need to refer to legal traditions, because still they are significant. But probably we are forced to engage in a more creative work. And this comes back to what Luisa was saying at the beginning, this distinction between an analytical work that's been done, an academic and scientific work, and what is there, knowing the formats, knowing the legal tradition, and on the other side, the effort of creating a rule. Well, these two aspects come together much more closely once these new issues are on the floor. Now, the question is, should we also reason about the methodology of the common core? Does this new landscape challenge somehow or create space for a new methodology or for any some change from that perspective? Thank you.
Thank you, Paola.
Shall we get a couple of questions more and then reply, maybe?
Okay. Are there any other questions? Okay, perhaps we can reply.
Okay. You start, Chef. I think it's good.
Right. Well, when you talk about the digital economy, it's clear that multidisciplinarity no longer means what it traditionally meant for most lawyers. That is, that you look not only at private law, you look at public law, you look at administrative law. You might look at economics, law and economics. You might look at psychology to study human behavior and the impact of law on human behavior and human behavior on law. What we now see is a very technical development where a completely different world is created, a digital world, but that you only see when you look at a screen. And we need to understand what that world is, how it works, before we can even start thinking about how to regulate it. The thing is, when you start thinking about regulation, also it's our notion of private law, public law, etc. that is changing. Our traditional ideas about how do you conclude a contract, do they still apply when it comes to smart contracts? Should we, in fact, regulate smart contracts through private law, or should it be regulated through public law? I can give you one example, if I may. What I see when I comparatively study blockchain legislation, what I see is, first of all, that it's the smaller jurisdictions which take the lead. In Europe, Liechtenstein. Why? They're tax havens, and they want to preserve their status as a tax haven by focusing on new technologies so that they can attract the financial services industry. Malta is another example, but let me focus on Liechtenstein as an example. What you see when you look at the legislation of Liechtenstein is that it is for the most part what we would traditionally call public law, regulatory law. You try to regulate those involved in the financial services industry using blockchain, smart contracts and tokens. The civil law part is relatively small and kept really simple. But is that the approach that we should take? That we should focus on public law regulation For the rest, leave private law basically to the actors in the field, because that is the signal that the Liechtenstein statute gives to those involved in blockchain and smart contracts. You can regulate it for yourself. The framework is very open. For the rest, if you stick with the regulatory rules, you're fine. So what I see is that we need a different approach to what it is when we talk about multidisciplinarity. And we also have to rethink what we traditionally call private law, public law. And added to that, and Paula is completely right, we should rethink whether perhaps we should develop a new type of law. That is why I deliberately used the term algorithmic law. Law completely designed for a standardized, computerized, software-based world. Do we need that or not? We should have a look at that at least. Some lawyers are not happy with that. When I talk to notaries, they always stress every notarial deed is unique. That is why you need a notary. Question: why is it impossible that in some countries 70 to 80% of all deeds of transfer can be completely standardized by a software-based process? So we have to rethink roles of lawyers also. So it's a challenge. And I think this project, this Common Core project, should face that challenge.
I would give two different answers, meaning that in terms of the fundamental choice about whether it should be normative or analytical, I still think that the choice that was made from the very beginning to be analytical as opposed to normative is sound. Because if you enter into the normative arena, then you have to select. And what we are trying to do is to see what is out there. So I think while I try to show that you cannot live in an isolated world, so you must be aware of what the context outside, whether Europe wants to regulate or not, whether you already have international rules or not, is absolutely relevant. But it's still that from the point of view of what you're supposed to do, I think that the choice of being analytical and therefore having no selection whatsoever, merely trying to map what is out there, is sound. The other part of it, Chef has made a brilliant example of this idea of the fact that our general categories are getting weaker and weaker. And when I was rereading all the materials, I remember that in one article by Hugo and Maro, they were saying, I know there are a lot of quarrels about the borders between contract, tort, and property, and somebody says, but this is tort here and it's property there, so you should make clear what kind of meaning you want to have. And I said, it's a meta category. It just serves our purpose of being able to map the law. Now, I think we should go about using the same kind of technique. We cannot be squeezed by the categories because otherwise we're losing sense of what we're trying to do, that is to describe the law. The thing is that it's far more complex than it used to be 25 years ago, because 25 years ago we were quarreling about the boundaries between property, tort, and contract. And it was quarreling, but still you could find your way. When you are trying to discuss things that belong not just inside law, and it's public law or private law, and it makes a lot of difference whether it's public or private in some sense. But you're also discussing the fact that you cannot purely just look at law, you should be looking at something else. Then the problem becomes that it's overwhelming. How do you do that? And I must confess, I don't have a clue. I'm really interested to see what the next session will come out. But I've got a sense by talking to colleagues and seeing what is written and what kind of research is going on, that this is really an issue. And if you continuing the Common Core somehow means that you need to take that into account and find some solution, which is definitely going to be difficult, but it's also, I think, the funny part of the challenge. It's changing.
There's a question.
Is it working? Should.
Since I'm originally from Brazil, I also saw the process of Europeanization of private law from a globalized perspective. And I have been working with the working team of Professor von Bahr in Osnabrück, and I could say that globalization is now very important also in that sense, because the DCFR is now translated into Chinese, into Korean, now into Japanese. And besides the European Union, also European countries like Moldavia now adopt, for example, the DCFR rules on tort law. This is now in force since March 2019. We have a kind of copying paste, that's what our Moldavian colleagues know, from the tort law DCFR now in Moldavia. And the interest, for example, also in the principles of European contract law is getting worse in Latin America with the principles latinoamericanos de derecho de contratos. So this is the approach that, if it's politically bad, the project of the DCFR, still it is very interesting for other jurisdictions around the world. And I would just ask you about more the globalization process, if you have some more information and news on that.
Should you want to start? Thank you. Well, this is very interesting. I didn't have this information. My reflections were more on the impact of instruments like the PECL and the DCFR in terms of building up networks of people that are working using that at least as a benchmark. So if you are teaching contract law, comparative contract law, comparative European contract law, of course, somewhere you need to tackle the PECL. And this is building up a habit, mental habit of knowing how to do things. And of course also in terms of the legal education, what kind of lawyers you are producing. But probably another area which I somehow looked at by looking at what was going on in the reforms of the German Civil Code and now in the reform of the French Civil Code, which clearly showed that they had in mind, although they were national codes and they were focused on national needs and national vocabulary and so on, it was clear that the reform was also meant to align the national system with European and international needs. So the sense that even though we can say that at the moment there's no prospect in Europe of any kind of codification. So it has gone back to the states. But it's the state now that are looking outside and trying to have some kind of convergence. Whether this is going to move on, I must confess, I don't know. I don't have enough expertise. But what you were saying is very interesting, that possibly instruments that were thought of as being connected to the European context, in fact, can work outside. That has something to do with our the Watson idea of legal transplant. How similar must a context be in order to have a meaningful transplant? Probably there's no single answer, but it's fascinating to see that all in all, things can be transplanted in contexts that are totally different. Think of China. I mean, if you think of one context, this is completely different. This is it. And it's clear that in their search for new rules, they are looking around them and they are taking also what is happening in Europe as an example. I think that we need to keep it as a context again. I would still think that analytical work is a different thing, but you must be aware that if these instruments, no matter whether the European Civil Code is enacted or not, are circulating and transplanted, that of course is relevant and needs to be taken into account in terms of where our work is connected. There was also something, when I was rereading the books, there were a couple of interventions by American lawyers that signaled the fact that even our claim as a group of being neutral is in some sense political. That what a legal doctrine does, even if, let's say, we are not worried about what you want to do, whether you want an act or code or not, we are just doing our work, which is to analyze things. This is a component of a broader picture where things are moving. Rules are enacted, and therefore we are somehow playing a political role, which doesn't mean that we are making political choices, but we are set into a context where things are interconnected. So that's a fascinating story. So, and I think that probably it could be something that could be reported for the Common Core just to have a sense. So thank you.
Well, let me first of all say that in the Access to Digital Assets group, we have a young American scholar who basically informs us about developments in the United States and who is not related in any way to the American tech industry, so he's completely independent. So we felt that that was very important. Then also the Access to Digital Assets project is in fact based on a model law by the Uniform Law Commission called Fiduciary Access to Digital Assets. And we learned quite a lot from that. First of all, the ULC drafted a model law, had approval from the tech industry. Then the model law was published, introduced in the legislation or the legislature of the states. And then suddenly the tech industry awoke, realized that it didn't like the model, and immediately began lobbying against it. And in every state where the ULC model was introduced, the tech lobby introduced its own counter model. Within a year, and that never ever happened in the ULC's history before, within a year, the ULC had to redraft its model. And it's the redrafted model that's now enacted in almost all of the states, but with the approval of the tech industry. I saw the letters in which Google said, for the time being, okay. We learned from that. So in a way, that is also globalization. We learned from that experience. So we took, in a way, the idea. Important for us is that the American model was taken over by the Canadians also in Quebec, so in a civil law environment. So we knew that the model would work in a civil law environment so that we could at least look at it for inspiration. That's globalization too. We work closely together also with the ALI, because what I tell you about the ULC, as you may have guessed, is inside knowledge. So we go to ULC annual meetings, we take part in ULC working groups, so we are there. We also work closely together with the ALI. Together with the ALI, we have a project on transfer of digital information, data, so contracts for the transfer of data. And that project is quite far. It will be discussed by the ALI in its upcoming annual meeting in San Francisco in May of 2020. So there is basically, it's not that we focus strictly on Europe. When we say European Law Institute, we know what's going on, and we focus on also what's going on outside Europe. We have one of our special interest groups focuses on global private law, and that group will meet in Canberra in February and will discuss blockchain and smart contracts. I will be one of the speakers, and we do that deliberately to get in touch with lawyers in Australia, New Zealand, Southeast Asia, so China, Taiwan, Vietnam, and so on. So we are very much aware of the global side of what is going on here.
Thank you very much, Chef. And thank you. There is still one question.
Mostly directed to SIF, but also to Luisa, because she mentioned the possible avenue that are open to European private law, discussing codification. Don't you think that one of the major flaws, or necessary flaws, we'll call it whatever, of the codification of private law efforts during the 80s, 90s, and early 2000 years was due to a relentless search for a compromise between civil law tradition and common law tradition? And if whatever you answer to me about on this point, don't you think that the time has come that we continentals could think of something in the direction of a codification, of some fields of the law, at least, in taking stock and making, bring it to fruition our continental tradition, our civilian tradition. And by the way, it's a piece of information I'm about to give. If some of you are unaware of this, there's an effort already started by the French and the German to try a codification on continental basis with continental roots of business law in Europe. So the codification dream or utopia or whatever is not dead for the time being. And I think that there could be some chances of rethinking, thinking over the process as a whole, starting from our tradition, our continental tradition.
Was another question, please?
Yeah, just very quickly, my question is about, I'm from Malta, my question is about algorithmic law and its relationship to traditional law. Whether, in a sense, theories of legal pluralism would, in your opinion, Professor Van Erp, be useful as something more than just a mystification in this process. In other words, it seems to me that traditional theories or other theories of weak legal pluralism, imagine that it, if employed in this context, would suggest the possibility of somehow harnessing or containing algorithmic law within a framework which is still fundamentally familiar to us. Whilst I can imagine a sort of radical critique to this, which would say that this would be just a mystification, because ultimately we're talking about a complete change in the way in which power is exercised, which is going to render law itself redundant.
Thank you so much. I'm not sure if I understood completely what you were implying, Chef, about this idea of algorithmic law. And I'm slightly worried of the optical illusion of separating the world of internet, whatever happens online, from whatever happens offline, so from the real life of the law. And I think that there are still lots of issues. Most of those issues are issues of private law, of property law, basically, mostly, about everything that has to do with the construction of the frontier in which your algorithmic law is working. In other words, I don't think we can take for, I mean, there is clearly a global transfer of capitalism on the frontier. I mean, there is a lot of production that is moving there. There are lots of firms that are, getting into the surveillance model or whatever in the cognitive capitalist model, platform economy. I mean, you mean it. And all of these are very, very quick changes that happened not in the last 25 years of the life of the Common Core, but probably in the last 5 years or so. And there is a huge acceleration going on and all of that. However, I think we should be, as lawyers, we should be cautious about running after this kind of technological transformations on their same ground. Like, for example, there is a huge optical illusion in considering smart contracts that are, computer programs that lawyers are not going to understand anyway, that are executed by machines in the Internet of the Things with other machines, in which there is, by definition and by structure, an asymmetry of power between the different programs and the different computer models and all of that, with contracts. There is a name which was borrowed by, is like, the code of Lessig has nothing to do with the civil code. I mean, it's just a name that is used there, is a completely different thing, and nobody, when Lessig wrote the book about the code, thought that he was talking about codification, right? We said, okay, that's a different name. So similarly, I think that contract in the idea of smart contract is just another name. It's just it's just a completely different ground of understanding, which is actually ruled and governed by a different professional group. They're not lawyers anymore that are the professionals there, but they are the computer scientists. On the frontier, this new frontier of capitalism, for the first time, I believe, there is no need whatsoever of lawyers. Capitalist extraction and reproduction can happen without us. And we are facing, as lawyers in general, not just practitioners, but lawyers in general, even legal intellectuals or legal scholars, we are facing for the first time the presence of a new category of people that are, not trained in the law, that are not lawyers, but that they are actually playing the same role that we've been playing historically for capitalism, which is helping out the transformation, the development of exchange value to grow. Okay, so that's another word. However, this is a word that is not completely separated from ours because the internet is not like discovering a new continent. It's not like when there was the discovery of Americas and then you have a new continent to discover. The internet is something that is constructed by accumulation of capital, which is governed by rules, and there are all the infrastructures. There are property relations that are going on today as we are talking about how to bring the data below the ocean arriving rather than in Los Angeles, arriving up in the northern part of California, and then all these data structures arriving in Las Vegas where the new centers of the self-driving cars are organized and so on and so forth. And these are very material issues. Very material issues. They are, cables and machines and energy and the impact on the environment and all of that stuff that is, and business and companies that make deals, real contract with each other, in deciding who is paying for what, who is organizing this and that. And all of that is a domain that is basically developing under secret or in ways that lawyers don't look at because we are all kind of busy trying to look as if the internet was some sort of an entity existing out there, given from God, that we kind of can inhabit with any others, and then we can play our role in governing that. I think there is a huge work to be done by lawyers, traditional nitty-gritty lawyers, commercial lawyers, private lawyers, public lawyers, to try to introduce some law in this kind of relationships that are relationships of economic power that are happening that are creating the conditions of the transfer of capitalism on the frontier. So there is a whole area in which probably the common law versus civil law still works, in which probably the law firms are still important, in which probably there are still important things going on in this kind of deals, and we don't look at that. Mega projects of that kind, huge projects of billions of euros and dollars that are necessary in order to create these new structures. Machines to monitor the underwater cables, all of that stuff. So I would be very, very skeptical in any project that would say, oh, today, we are on the internet, and therefore we can kind of play our role as lawyers at that direction, at that dimension. There is the good old dimension of lawyers as, helpers / slaves / critique of capitalist reproduction that we can still and must still play, but we are not playing because we are kind of falling in love with the algorithmic dimension, and we are hypnotized as a profession by our smart devices. So I would be careful about that. And also the miracles of the blockchain, I would be very, very skeptical, because there is something that is called trust that has nothing to do with the technological dimension. Trust is something, it's a human relationship, it's something completely different, is legal from a large perspective, has nothing to do with the structure of how a computer program is organized in a leveraged technology.
All right. Just reply quickly. Do I see that we focused wrongly on the distinction between common and civil law? No. It's clear that there are two major legal traditions worldwide, and the work that I do for the European Law Institute is not a European Union Law Institute, it's European. And no, but it has an impact. Because some might argue that after Brexit, happily, we are now, we are without the common law, forgetting, by the way, about Ireland, the Republic of Ireland. And in fact, in a note written under the Henri Capitan project on business law, you find that sentence literally. Now that we are no longer troubled by the common law, we can focus on the civil law and we can codify. And I warn against that. I think the major problem with codification attempts in the past was that those working on it were too often academics and not practitioners, and ignored the political reality. And in the case of the let's say the Franco-German project, we should not forget that the whole draft common frame of reference was torpedoed also by the French and German governments. So the letter was crystal clear. Then about algorithmic law. Well, I expected some reaction there. The way I look at it is when we were first discussing consumer law and general terms and conditions, we had traditional contract lawyers saying that has nothing to do with contract law. This is mass contracting. So this is not contract law. This should be seen differently. The difficulty, however, is that general terms and conditions already were widely used 30 years ago, and we had to find a solution. The solution was they're binding, but you protect consumers against unfair terms and conditions. I did not argue that, let's say, algorithms, purely algorithms, could govern us. There has to be a justification for that. And so the question is, when I have debates with data scientists and others, the question is, who decides about the legal validity of what is going on in the digital world? Is it indeed a programmer who says, if I program it A, B, C, it is A, B, C? Or is it a lawyer, a court, saying, I don't care whether you call it A, B, C, I will not recognize it, because I apply a different system, a different way of approaching human relations. And then, of course, I agree, priority is with the law, not with the computer programmer. At the same time, I cannot deny what I see happening. In London, firms working on mixed hybrid contracts. Part of the contract is traditional, part is governed by smart contracts, because that part is standard. So we cannot close our eyes to that aspect of what is going on. However, in the case of a hybrid contract, the traditional part is there to make clear that you're bound by the smart contract. And when it comes to the term smart contracts invented by Nick Szabo, I can give you the references when Nick Szabo himself says that he regrets the term and said I should never have used it, because lawyers misunderstand me.
Thank you, Luisa.
Yeah, of course, I cannot. I think Chef has much more expertise than me on the specific things of blockchain and all these kind of technological things. A few thoughts that came when Mauro was talking about the distinction between common law and civil law. That's interesting, because when I was looking at the books, and there was a piece by Matthias who said 10 years evaluation of what was going on in the Common Core, and he said, well, if you look at the results, it clearly comes out the cleavage is not between common law and civil law. There are distinctions, they are important, but they don't usually come under the boxes common law and civil law. So I don't have a reply, but it seems that maybe this is something to reflect upon. And the other interesting thing of your question and remark is the fact that since it seems that right now the European Union is not in a position to have any political will to move on towards comprehensive integration, you may have something that is more bottom-up, I would say, that you might find states that think about joining forces, and that is something maybe that is moving us more towards the American experience of the model laws or something, but I have no clue, but it's interesting. And about Ugo, I think one of the things that constantly comes to my mind in the work I've been doing these years is about taxonomies in law. I really have the sense that we're very much, we cannot but work with taxonomies, but there's something that every time that we're trying to do something, we are straitjacketed into these taxonomies. So maybe these areas that Chef was mentioning and you were talking about really need to, if you want to bring together the analysis of phenomena that are related, but as you said, are completely different, because there are parts that are old-fashioned law and there are parts that are new. Maybe, first of all, developing a vocabulary and a taxonomy that will help you analyzing the phenomenon is a crucial issue. And maybe that's a good group where some work could be done. Thank you.
Thank you very much. And just before closing, I was intrigued by the question of Mauro about the codification, because, of course, it was not addressed to me, but I'm working a lot on the European codification. I was thinking that maybe one of the issues which we might think about is taking into account the mass of European law in the sense of positive law nowadays, because the European law is building up a terminology, and somehow, of course, it is not a system, but it's building up some categories. And one of the reasons why the draft common frame of reference was not really used was because it was completely disconnected with EU law. And so perhaps this is nowadays one of the issues in which we should reflect. And if we think about this European codification, we should also take into account this area of the law. Okay, so I have to do my job as chair, and so we have to close, and it's time for lunch. So thank you very much for the speaker. Thank you very much for the very stimulating question, and thanks a lot to you all.
Take place in the foyer where you registered this morning, where the coffee break was.